Commissioner Kasher,
Here.
Commissioner Wasserman,
Here.
Commissioner Wynn,
Here.
Chair Remke.
Here. Unfortunately, Commissioner Eskovitz can't make it due to a work conflict. He notified us this morning.
If I could be recognized, please, Madam
Sure.
Chair. So I'd like to announce that, thank the governor and announce that Jody Remke, our chair, has been reappointed. And I'd like to congratulate her and really just say how personally pleased I am. She's a great chair. And I think she has a nice vision for moving this organization forward. And I'm just very happy about it and wanted to congratulate you, Jody.
Thank you.
Congratulations, Chair Remke. Very happy that the governor has reappointed you and look forward to working with you over the next 2 years for me.
Thank you. Okay, and I would also like to acknowledge another appointment by the governor. Some of you may have heard our General Counsel, Zach Morazzini, has been appointed to Director and Chief ALJ of the Office of Administrative Hearings. That came out yesterday, and Zach will be departing immediately, unfortunately. So this is his last hearing. Congratulations, Zach. We wish you the best of luck.
And thank you, Zach. I want to thank you also. Thank you for your work here, and I wish you the very best in your new job. Congratulations.
Zach, I've told you personally, but I also wanted to mention in front of everybody, really appreciate all of your work on behalf of the commission. It's been a pleasure to work with you, and wish you the best of luck in the future. Yeah.
Congratulations, Zach. And I thought, it was too good to be true to know Jody's coming back and here, and then you're moving on, but congratulations and best of luck.
We don't like to keep things too stable yet at any given time. Change. Erin, you had a couple announcements as well.
Yes, in the theme of keeping things interesting. I just wanted to also, on behalf of the staff of the FEBC, congratulate Chair Remke for her reappointment. We're looking forward to working with her for the next 4 years, and we will also miss Zach as our general counsel and hope to hire an equally fantastic general counsel for the commission in the next couple months. And I also wanted to welcome Dave Porter to our commission. He is our new Chief Information Officer. He's actually sitting right there. He waves, raised his hand. We're very excited to have him. One of the chair's primary focuses is ways to utilize better technology to help increase transparency and disclosure and further the work of the commission, both for external stakeholders and even internal efficiencies. And so I think, having a good, strong CIO is very important to that mission. And Dave brings to the commission about 20 years or more of IT experience, both in the private and public sector, and also was an investigator and an auditor at the Franchise Tax Board in a prior life. So he also has some sort of back in the day good experience that will help him understand the core mission of our agency as well. And I'm also happy to announce that this year the commission also has another executive fellow. Her name is Vanessa Garcia. I think she's there.
She's in San Quentin today.
Oh, she's in San Quentin.
Things weren't going that well.
Yeah. Just to clarify, she's on a tour of San Quentin. Anyway, so Vanessa, I couldn't be here, but she'll be here at another commission meeting. She's a recent graduate of UC San Diego and was very active in the UC Students Association and other lobbying activities during undergrad. So she has good exposure to state government, and we're really excited to have another fellow this year.
Welcome.
Yeah, sitting. I think there's some chairs in front if those people in the way back want to sit. Okay. Before we get started with the listed agenda items, is there any public comment for an item not on the agenda? Okay, seeing none, we are going to, first item 2 would be approval of the November 2014 committee meeting minutes.
I move approval.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes. Okay, those have been approved. Now we'll move to the general items. We're going to take things a little out of order today, mix it up.
I like it.
Oh, actually.
Sorry.
Are we right? Okay, we have 3 or 4 actually amendments to regulations to talk about. We'll start with item 3. What's going on?
No, just item 3 is the TAD manuals and forms. And so
Okay, right. Sorry.
I think they want to do that first. If that's
I
okay.
do. Thank you.
Good morning, Commissioners. Linda Cassidy, Division Chief of the Technical Assistance Division. As my memo points out, we have 4 new revised campaign manuals that we hope to post this month, and a revision to a campaign form that resulted from new legislation regarding ballot measure advertisements. All the material has been posted on our website for comment, and I provided you a memo yesterday on some that we are going to incorporate some of the comments regarding multi-purpose organizations and on the IE report. They were good comments and will help make the manuals user-friendly, which is the goal. So I ask for your approval.
Are there any questions?
I have a comment, not a question. You guys did a great job with these manuals.
Well, thank you.
I had never really spent time with them before, and really kind of went through to see. I love the frequently asked questions, and I really liked the little
My examples and quick tips.
quick
Yes,
tips.
everybody loves
It
those.
was really
Nobody reads
nice.
the-
It was such a quick, easy way to
Mhm.
distill things down to their real kind of basic essence, and I just thought they were really well done. And with that, I'd like to move approval of
Thank
the
you.
manuals and form.
Second.
Roger, public comment on?
Oh,
Yeah.
I'm sorry.
Sorry.
So first, we're going to go with, is there any public comment regarding the manuals? We have someone coming.
Good morning, Betty Ann Downing with California Political Law based in Long Beach. In my personal perspective, as a matter of public policy, the first priority of a commission like this is education and training, and that's what it should be. And so I really appreciate the fact that the manuals have been updated and are now going to be available very shortly to the public. We represent, our firm represents candidates and others involved in the process, so they've got some advice, they've got some guidance professionally. A lot of folks don't at the local level, small PACs, they don't have a guidance. Can't afford it. So these manuals are really invaluable. So I want to say thank you so much for
Thank you.
updating them.
Thank you.
Thank you.
Chair, I just wanted to add to there's 3 other manuals, Linda, 3 or 4, and the goal is to update all the remaining manuals by hopefully this summer. So by the end of
June 2015.
Right.
Yes, that is the goal, and we are on target. Yes.
Great.
Great.
Okay, now is there a motion?
Move to approve the manuals and the form.
I second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, now we'll go to the regulations. Item 4, Regulation 18450.11.
Hello. Good morning. Chair and Commissioners, Suki Brar, Senior Commission Counsel. These amendments to Regulation 18450.11 seek to incorporate amendments made to Section 84511 regarding spokesperson disclosure by AB 510 last legislative session. Basically, now there's an additional requirement in that section that when a committee pays somebody any amount to appear in a ballot measure ad, and that ad states or suggests that individual is a member of an occupation that requires specialized licensure, certification, or training, that committee file a form and add an additional disclosure on the advertisement. So these proposed amendments seek to incorporate those changes into our existing regulation on that section. Staff recommends the Commission adopt these proposed amendments. Thank you.
Thank you, Suki. Do the commissioners have any comments or questions regarding
No.
item 4?
No.
Is there any public comment? Okay, seeing none, I move to approve item 4.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yep.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes.
This motion passes.
Thank you, Suki. Okay, item 5.
Good morning, General Counsel Zach Morzini. I'll be handling this regulation myself. It's a fairly straightforward effort to streamline the process through which Form 700 filers can request to withhold information regarding the identity of a source of income based on privilege. The former regulation was limited to staff only looking at California law. But as you probably recall, the last two items that came forward under this regulation involved federal law. So we expanded the regulation to allow us to look at state and federal privacy laws. And we also streamlined the process so that the everyday type of requests don't have to come before the commission for a full vote on an opinion, but rather can be handled internally by the general counsel with oversight by the chair. Happy to answer any questions you might have on this.
Commissioner Wynn?
So in the very last paragraph on page 2 of your staff write-up, so if the general counsel grants the exemption is presented to the chair, and then the chair approves that recommendation. And then how is, I was not clear the procedure whereby the commission is just notified. I mean, does it just become a part of the chair's report out to the commission, or I'm just not quite sure how that happens.
Sure, if it's approved by the chair without being elevated to the full commission for review. Yeah, I think it would just be a memorandum the general counsel could send to the commissioners, just informing them that this was.
Or even just to report out at the,
At the next
chair
hearing.
normally does a little announcements at the beginning. I mean, it could be very informal, but, I
agree.
don't know if we need to, put that in the regs or just make a note for the record, but just so that the commission is
Right.
notified, so that we keep abreast of what's going on.
I think it's a really good point, and I would agree that I think it would be, information would be provided at the next
Yeah,
hearing.
super. Yeah.
We could codify that, or it could just be the internal policy.
I don't have a preference, so.
I would leave it to the internal policy at this point if the other commissioners are okay with that.
Great.
Yeah.
Yeah, I mean, we can address that further. I like the fact that we've put this into a measure where the public can get the information, the candidate or the filer can get resolution within a reasonable period of time rather than the current rather cumbersome method. But I do think it's very important for it to be reported back at the commission meeting in order, more like just as a summary of exemptions were granted to, I think there's a report on advice letters, et cetera, perhaps in that same methodology.
Absolutely.
Yeah,
It could be included in legal division report. And fortunately, they're 1 to 2 a year, so it
Yeah.
won't add much
Exactly.
verbiage to the
We'll
report.
highlight them so we don't skip them.
Sure. Great comments.
Thank you very much.
All right.
Sure.
So with
Thank
that,
you.
I move, oh, no, you want to ask for public comments.
Yes. Is there any public comment on item 5? Seeing none, is there a motion?
I move to approve this regulation.
Second.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, item 6.
Good morning, Chair Remke and Commissioners. I'm Bill Lenkite with the Legal Division. This item presents the final segment of staff's proposed amendments to the materiality standards as part of the process of revising the Act's conflict of interest regulations and addresses financial interest in source of income, source of gift, and personal financial effects. Staff's memo summarizes the issues undertaken in this project, and staff is prepared to answer any questions that the Commission may have. In addition, as always, we've had public outreach and did an IP meeting, and we've gotten input from the public. And I would especially like to thank Mr. Sean Mason from the City of San Mateo, who has always been helpful, and he's been available to talk to me. Aside from his duties as the City Attorney of San Mateo, which keeps him very busy, he's always found the time to provide his input, and I want to thank him for what he has provided. There are 2 issues in his letter that I'd like to briefly address. The first one, to the left of your microphone, you should have a page with some proposed amendments.
Yep.
And those amendments are being made for the purpose of clarification from input that he provided. And it's you write something and you think you understand it, and someone from the outside reads it, and then they come up with a different view, and you you realize things like that. So we've made those changes, and I think we're all agreed on that. The second was a little bit more difficult, and that involves the language under 18705, the first one. And we had this discussion at the last meeting when we were going to try to add in some language that would make it clear that we were no longer going after one penny effect type things, and small, minimal, trivial, whatever type of effects were not going to be considered material. So we tried to add some words in. And we agree with Mr. Mason that we should probably take out the word immeasurable because it's just redundant. But we would like to leave in nominal, inconsequential. Insignificant, I think, has a broader meaning than what he states in his letter. It means more than just not significant. It means lacking in importance, trivial, lacking power, position, or value, worthy of little regard, small in size or amount, having little or no meaning. So we think that word adds something. We would also be willing to add a couple of other words like minimal or small or negligible to get the point across if that helps. But we're not really comfortable with his proposal regarding the use of the word tempt and the phrases that he used there. And we're not really sure where that would where that might lead, and we don't really understand how that adds anything other than, to us, it just adds more confusion. But he's here, and he can speak on it, and we can talk about it.
But let's focus first, because that's kind of a different issue on the 18705. So are you asking us to consider amendments to what's been presented at this point?
Yes.
So how would that, I understand, well, there's two sets of amendments. The one
Okay. The one that you have before you,
yeah, that one we see.
and then the one on 18705,
And
which
has this been available to the, as it's out in the hallway and available to the public?
no, I think we need to put that out there.
Well, and
Yeah.
I'd like, so to that extent, if we
Yeah.
could just be a little bit more particular and just read the sentence that
Yeah.
you're proposing the changes on, which are, I would say, technical and clarification, but just so we're all on the same page as to what's happening. And again, that's, which one? Yeah,
There would
no,
be
okay.
exception number D on
18705.3.
18705.3.
Okay.
I just ran those copies off a few minutes ago, so I don't think that they're out there yet. It's hard to get to the photocopy machine on commission day.
But just so we're clear.
Have an extra, I can make a bunch of copies.
Go ahead. It's on page 5 of 18705.3 at line 23. Starts with exception. Or you have a page, so.
Yeah.
And the shaded part on your copy would be the addition, and the strikeout obviously is the strikeout.
So if you could just say, so the part, read the
I will
sentence,
read
the
the
retail
part.
customers of a company.
Starting at the beginning of line 25, significant segment of the public generally, if the business is open to the public and provides goods or services to the customers that comprise a broad base of persons representative of the jurisdiction as a whole and not confined to any specialized profession, occupation, or business.
Okay.
And this is what is agreed to.
Yes.
Okay. All right. That's the first amendment that's being proposed. And then let's go back then to 18705, just so we're clear on what the language is as it would appear if we, excuse me, adopt this. So right now it says the financial effect of a governmental decision is not material if it is nominal, inconsequential, insignificant, or immeasurable. And you want to propose the amendments to read.
Strike immeasurable and add minimal, small, or negligible.
So it would be or minimal, small, or negligible.
Yeah, or you can, or move the or to the
minimal,
end.
small, or- yeah. Okay. 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 Just want to make sure. I think, so is that it for you, Bill, at
That's
this
it for
moment?
me, yeah.
All right. And then, Mr. Mason, if you want to come up, and I'll hear from the rest of the public as well, but since we're addressing some of your concerns right now, let's.
Thank you. First, let me add my congratulations to you, Chair Emke, and to Mr. Morosini. It's been a great pleasure working with Zach. He's been very open to sharing his perspective, and the perspective of legal staff with us, and I truly appreciate that collaborative opportunity to work with him. So yes, with respect to the comments made with respect to subsection D, the exception, Bill and I looked at that this morning. I agree. I think that's fine. The edits that he suggested. And then with respect to the standard, let me first make it clear that from our committee's perspective, we would prefer to keep the $250 in a 12-month period standard. That gives us a sense of magnitude in terms of what we're talking about. But consistent with, and we recognize that over the last several months, when we've talked about the other standards, it's the interest of the commission to move towards more qualitative analysis rather than these quantitative standards. And so with that in mind, I was giving some thought as to alternatives to the words that were suggested, because I think my issue with the words that were suggested is they don't give us as advisors sufficient guidance in giving advice to our clients as to what will be considered nominal, minimal, small, etc. And the other concern is that this, what I call the relativity concern, is small, is inconsequential, is nominal relative to the financial condition of the official or not. And the list of those words doesn't answer that question. And so I think that I would suggest that some effort be made to address that question in whatever words that you come up with. And as to the words that you choose, Bill and I had a conversation this morning. It's this, if we do move away from the, $250 per 12-month standard to either the words that I suggested or the words that Mr. Lenkai has come up with, I think the end result is going to be that we advisors to officials aren't really going to know the answer, and we're going to be asking your staff more and more frequently what the answer is. And I suspect as we had this conversation with respect to the real property materiality standard, over time, as more and more opinion letters get out there and we get to see how this works out in terms of specific facts and how it's applied, we'll get a better sense of what the thinking is behind the standard. But there's going to be a period of significant discomfort for us, and so those are the comments that I'd make. One last comment as to the words that were provided, the alternative language. One that comes from me, not from the committee, and the other is that the words. Bill and I had a conversation about the word tempt and some of the other words in the regulation. They actually come from a case that was cited by Mr. Lenkai in a report on, I can't recall, I think it might have been the real property regulation. And it's a discussion from a case that's talking about what are we trying to get at in conflict of interest law. And what we're trying to get at, the policy is, we don't want officials to be in a position where they could be influenced by their personal finances in making the decision as opposed to the public interest. And so that's what it was trying to capture, that policy, and actually state that policy in the regulation itself, as opposed to listing words like small, nominal, and inconsequential. So it did come from the word tempt was used in the case, and that's where it came from. Be happy to answer any questions.
Are there any questions? Yes.
I don't have a question, but I do have a comment. First of all, I'd like to thank you two gentlemen very much. I think your public dialogue has really enriched this process, and I think we're in a much better position with these regulations thanks to your willingness to just keep talking publicly about this. This document has just gotten better and better and better, and it's because you two have been so open-minded with one another and with all of us to just let us into this conversation. So with that said, I don't know that we need 6 adjectives to come up with small. And we do have 6 adjectives now. And I think kind of the first 3 do pretty much encapsulate that we're really talking about something very nominal and small. And even if we could agree on 4, I think 3 would do it. But even if we could agree on 4, I'd be comfortable. But 6 seems like overkill. So that's my only comment.
So we're taking votes now on adjectives.
I think the first 3 with the removal of immeasurable, which I agree doesn't really add. We're talking nominal. Nominal is actually a pretty clear word. And inconsequential paired with nominal pretty much gives you what you're looking at. And then when you add insignificant, that's a pretty clear picture at that point. So I think adding minimal, small, and negligible don't improve the adjectives in my mind. But Mr. Mason, if you're more comfortable with a few more adjectives and it gets us where we need to be, I'm comfortable with that. But I really think maybe changing the or from after insignificant to before insignificant and removing the word immeasurable, in my mind, does pretty much get us where we need to be. But I'd love to hear the other commissioners comment on that. So.
Yeah, I believe we were trying to address some concerns about those words, but I, by all means, comfortable with 3 words rather than 6.
Likewise, I would support that. And it seemed that the additional words were really to address the lack of clarity with the measurable. So yeah, I would support that.
Commissioner Wasserman, are you okay if we go back to the removing immeasurable and leaving it at that's the discussion right now?
No, I'm following the discussion. I think about it myself because I thought more words gives more opportunity for more misunderstanding or attempts to put them together. Even though the actual goal, I see the goal was trying to sort of triangulate down to be very clear. What I've been thinking about is the comparison between the proposed language 18705.5 that Mr. Mason had presented, setting it forth as a reasonable person standard about and this idea of quote tempt, which you derive from a decision. So I'm completely in agreement that we should sort of cut the words down. I don't really think we need probably more than 1, but I'm not going to begin to hash into that. I think immeasurable can go, and we'll work with that.
Okay, with that then amendment, we have the 2 amendments, one to 18705 and one to 18705.3. Is there any further comment?
One little piece of business I would like to accomplish is to get a sense from the commission on this question of the relative financial condition of the official. Mr. Lenkite and I spoke, and I think we were on the same page in terms of the way we see how the rule works. When we're talking about personal finances, impacts on personal finances, the standard ought to be the same in terms of the outcome. It doesn't matter whether you're talking about Warren Buffett or someone on Social Security. And
I think I can suggest a solution here.
Well, if it's adding more words at this point, is that? Go ahead.
It would just add the not. First, let me say that this is in 40 years history of the act. Nobody has said that you would measure your financial interest based on how rich you were, so it's not really a problem. But maybe if we just add a reasonable person would find the financial effect is nominal, inconsequential, that might take care of the problem.
Again, I'm not sure that addition is necessary. These regulations are applied
I'm just making a suggestion.
historically to a reasonable person.
That's how it
So
would
my
be.
recommendation would be to not change it, but to clarify, for the record that
Right.
the staff does not, or attorneys advising their clients does not consider the relative wealth of the official.
And that's why I said it's never been a problem before. Nobody's.
I feel like we just keep littering the regulations with the word reasonable as many places as possible. I think it's clear we're talking about a reasonable person under the facts and circumstances.
I
agree.
Okay. All right, so we won't take that change. So item 6 with the proposed amendments. Oh, I am sorry. Yes. Is there more public comment? Okay, seeing none. Now,
So I would move approval of regulations under item 6 with the 2 proposed amendments submitted by staff.
I second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay. Item 7 is informational. Thanks.
All right, Jacob.
Good morning, Commissioners. Jacob Bytel, the External Affairs Coordinator, and I'm here to give you a brief rundown of the end of the year report. The report is available online, and for members of the public, there are additional copies out in the lobby. Unlike previous years, which have focused more on the Enforcement Division, this year's report gives a more robust and comprehensive picture of everything the Commission accomplished over 2014. With that said, it was a banner year for the Commission. The Enforcement Division had a record number of prosecutions. Using our limited resources, the Commission handled over 1,000 cases, which resulted in proven violations of the Act. We also had a record number of campaign money laundering cases, which, as you know, are very difficult to prosecute and often take much more time to process. But in 2014, we more than doubled the previous record. And we also had the most proactive cases open in the Commission's history, building on last year's trend of trying to achieve compliance with the Act during the election when it matters most. The Commission proactively opened more than 100 cases than last year. And on the non-enforcement side of things, the Commission contended with over 40 pieces of legislation, 8 of which were signed by the Governor. The Commission also continued its regulatory overhaul of conflict of interest regulations. We improved 16 regulations over the year. And we also provided advice on over 22,000 inquiries that were submitted to the Commission. In addition to the impressive numbers, the Commission also hosted a symposium celebrating our 40th anniversary. We produced a broadcast quality documentary that continues to air on Cal Channel. We launched our top 10 lists that provided important disclosure to voters during the 2014 general election. And we implemented 2 very significant bills, AB 800 and SB 27, which were no easy feat. On top of all of this, the Commission continued to expand our educational outreach efforts. I'd like to draw your attention to pages 18 and 19, which give greater detail on our outreach and enforcement statistics. As you can see, 2014 was clearly a busy year for the Commission. I know I am proud of everything that we've accomplished over the year, and I think this report shows that we all have something we can be proud of.
Thank you, Jacob. You guys did a great job on the report. Erin?
Yes, I'd just like to echo what Jacob said. I think it's important to show all of the hard work. It's easy to get sort of lost in the day-to-day, but it's nice to see a comprehensive report of everything we accomplished. And just to remind everyone who thinks that we have hundreds of employees, we have about 75 to 80 people that work here, depending on how you count them. And so it's a tremendous amount of work, especially during an election year, that we've accomplished. And I especially want to thank Jacob Bytel, Vanessa Garcia, Enrico Avesa from our information technology unit. She did all the graphic design work on the report, and I think everyone can agree that both the narrative, which Vanessa and Jacob worked on, and the just production, the layout of it is fantastic, and we're very proud of it.
Mm-hmm. Yeah, I'd like to just echo, great job. This is really just such a nice, concise snapshot of where we are 40 years in, and that was such a significant year for us, and really want to thank you for your efforts. It's really a nice piece.
Yeah, I wanted to personally thank staff for all of your work throughout the year and everything that went into here. I took a lot of pride in reading this report, and I thought it was very well done. And I often get the question, what do you guys do on the Commission? And this is nice to be able to point people
just
to
hand them
one
that and
report,
walk away.
yeah, that can address that question. So thank you guys for all your work.
Yeah, thank you.
No, I actually agree on that. I'll probably do that. I refer people to the website about us. I say, okay, go to the website, click on our annual report, okay, and then we can talk further.
Okay, now we'll move to the enforcement matters, items 8 through 25, the proposed consent calendar. And would the commissioners like to take off any items before we get started on the consent calendar? Any? Okay, I don't see any. Go ahead.
I don't want to snatch defeat from the jaws of victory, so maybe I'll just be quiet. I really don't have anything to add. If there's
Okay, so do the commissioners have any questions or comments?
I just have one comment. And once again, Gary, very nice job. This is such a big agenda, and to just read through it, it just really shows how much work you're doing, and I really appreciate it. And with that, I would move approval of the consent calendar. Although we need to
Is
ask
there
for
public
Yeah, public comment.
Yeah.
Public
and- you got somewhere to be.
I just keep getting ahead of myself. I'm really interested in what you all have to say.
I do just have a couple comments or ask looking for clarification starting on item 15. And I don't know, Gary, I'm sorry if you don't have the information in front of you, but I do note in the stipulation under the proposed penalty, it talks about that we are considering whether the behavior in question was inadvertent, negligent, or deliberate, and respondent's pattern of behavior. But I don't note either of those issues addressed in the stipulation itself. Were those, do we know the answers to that?
Yeah, thank you, Madam Chair. I didn't say it before, Gary Winnick, Chief of Enforcement for some people. We are actually required, obviously under the Act, to consider for every case whether or not it's deliberate, negligent, or inadvertent, and we do. We don't always articulate it in the stipulation. I think generally we try and put it in there where we're deviating from sort of the standard precedent for penalties. So we want to give you some more information to understand at least what our thought process is in the recommendation. This case, we didn't do that, obviously, which is why we're highlighting it. Mostly because I thought we thought it was a sort of a routine case. So I think if we thought if it was a deliberate violation, we would obviously have put that in there. But this is sort of, I guess, more run of the mill. We can put those in.
Well, no, I guess my question
Yeah.
just was, it says this is how we've reached a proposed penalty, which is fine, and I understand that those are the factors we always consider.
Right.
I was just wondering if there were particular actual facts to this case that were
I see what you're saying.
missed in the factual discussion as to why these 2 points were highlighted. For example, was it intentional? Is there a pattern? Again, neither of those.
I'm sorry, I misunderstood your
Yeah.
question. I apologize. There was no evidence to suggest that this was intentional in this specific case. The respondent is a government agency, and so generally sort of you get the benefit of the doubt that you're not intentionally violating the act. But there was no evidence that we had, and we probably should have articulated that as well.
And that this is not a pattern of behavior.
Correct, yes.
Okay. All right. That's all. I just wanted to clarify that. And then I think there was just a clarification on item 21. And I note that in a couple places regarding this matter, it talks about the respondent not having submitted 2 reports. And I just wanted to clarify whether or not those reports have in fact been submitted.
Yeah, thank you. I did check this morning. The reports have indeed been filed with the Secretary of State. The language in here obviously should read to reflect that. So that's our fault. It's an error.
But that's okay. Okay, so they have been filed. That's great. Okay. Any other questions?
I had just 2 quick ones. On matter 10.
Sure.
And this goes to the first question that was raised by the chair and the issue of whether or not inadvertent versus intentional. In several of the counts related to, it was the re-entering or the reapproval of the agreement.
Right.
And there was a reference to the manager kind of signing the staff report. And I'm wondering if there are any facts to suggest that he was, that because sometimes that's just a staff recommendation and he's just signing that. And there may be a bunch of other matters that are also in that report, or was he instructing staff directly to approve the contract?
Let me give you my half answer because I'll give you my understanding. And to be honest, to do that, I would want to re-review the case file to make sure I'm giving you a fully accurate answer. To the best of my memory from this case, it was him approving the staff report, not so much directly intervening with staff. But I just want to caveat that by saying I would want to take another review of the file just to make sure I'm giving you the right answer.
Yeah, and that's fair. And it's more of an issue. It goes to the mitigation.
Sure.
And there's clearly a violation there. I was just
Right.
curious if there was.
That's my recollection. I mean, I did review it, but again,
Yeah, that's
I
fair.
just want to make sure I'm not misleading you.
Okay. And then I just had one other question as it relates to 13 and 14.
Sure.
And it appears that those were brought to our attention based on a franchise tax board audit. And I was just curious about that process and how often we receive referrals from the Franchise Tax Board? Is it in the form of a request to investigate or just notice of some impropriety, suggestion
Right.
of impropriety or anything?
Franchise Tax Board does their mandatory random audits off of a draw that we do. In fact, there's one coming up in February again. And they generally work on a 1-year cycle now with a bill that was passed a 2-year cycle. When they complete their audits, they make findings. So if there is a material finding in audit, which there isn't always a material finding, any audit that has a material finding, they transmit to us. And we generally get those once a month, sort of on a rolling basis. When we get those in, we then review them to see if we're going to take any kind of enforcement action. Sometimes the material finding is enough from our perspective. And again, we try and maintain consistency. Sometimes it results in a warning letter, and then sometimes it goes forward to where there's an administrative fine that's sought. But every month, basically, we get a new shipment, if you will, from the previous month.
Okay, thank you.
Thank you.
Yeah.
Any other comments from the commissioners? Okay. Is there any public comment for the items on the consent calendar? Okay, seeing none, I move to approve the matters on consent items 8 through 25.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, I believe the last item are the executive staff reports. Do the commissioners have any questions for staff on those reports? I believe Suki. were you
Unless there's
gonna-
questions.
Okay, just unless there's questions. Are there any questions? Okay, if there are no questions, those will be submitted. Are there any other questions or comments? All right, then I move to adjourn the meeting.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes. All right, thank you.
Thank you.